If I were the defense attorney for any of these defendants, and there was even a remote possibility that my client would be indicted, charged in another jurisdiction, I would be in touch with that prosecutor before, or at least simultaneous with my discussions with the DA, because I know the prosecutors are going to talk to each other. I know that they've already saying, "What are you going to offer?" and "What are you going to offer?" So they're talking, and I would be ineffective if I didn't try and come up with a resolution ahead of time. I'd be very surprised if they haven't had discussions with uh, Mr. Smith.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. Today we are talking about something interesting in the state of Georgia. I don't know. You might have heard that there's a small little case going on against the former president of the United States and many of his associates, we'll call them. We've been struggling for a title for this episode. It started out Cheese and Kraken, but then we had one more plea with Jenna Ellis, so we have to figure out a different name. But the truth is, we all know what's happening. There's been 4 pleas now in the RICO case in Georgia, in the state of Georgia, and it's 3 lawyers and a bail bondsman. And so the most recent are Kenneth Cheeseborough, Sidney Powell, and Jenna Ellis. And we've been really, really wanting to talk about this on the podcast for a while because these pleas happened a few weeks ago. But, you know, Mark and I, we're mostly federal guys. So it took us some time to track down just the right state, Georgia lawyers who are intimately, deeply familiar with the state system to illuminate and enlighten us on this situation. So I am so excited to say that helping us get set for sentencing today are 2 fantastic Georgia defense lawyers, Jeff Brickman and Tom Church, along with our returning champ, of course, Mark Allenbaugh. Mr. Brickman, Mr. Church, how are you? Thank you for being here.
Fantastic. Thanks for having us.
All right, so let's do some introductions real quick because everybody knows Mark and I, but I'll start with you, Jeff. Tell me about yourself. Anything, your origin story.
I grew up in Atlanta. I've been married 30 years to my wife, Susan. We have a 28-year-old son, Joseph, who's a lawyer. I was a state and federal prosecutor for 15 years and have been a state and federal criminal defense attorney for 18.
Excellent. And you have your own firm, yes?
It's Jeffrey H. Brickman, LLC, and I look remarkably similar to my IT and marketing person.
Excellent. All right. Thank you. Tom Church.
Well, again, thanks for having me on. I'd love to say it's an honor to be on a podcast with Jeff. Jeff's a great attorney here in Georgia. He's got everyone's respect. And, I can only hope to emulate his career. I've been out of law school for about 6 years. I've got my own firm, the Church Law Firm. I'd say about half of our cases are federal. But besides that, we're in, felony cases around the state of Georgia, including in Fulton County. And much to my chagrin, I find myself in Fulton fairly often. So always a good opportunity to talk about that particular jurisdiction and how things work down there.
And I think it's going to be really interesting. You've got federal and state experience because, it's part of our goal today is to sort of compare and contrast between what's happening there and what we're used to in the federal system. So that's what we're going to do today. We're going to talk about what happened specifically with these 3 lawyers behaving badly, what it all means, do some compare and contrast, make maybe some predictions for what comes next for these individuals in the whole universe of criminal cases that the former president's dealing with, and just see what is happening. Because I'm looking at these things, and I just want to start out with, tell us about these. I watched these pleas when they were televised and they unfold, and there's something called a First Offender Act. It sounds like all these pled guilty under something called a First Offender Act. Have no idea what that is. Can someone enlighten me?
Well, it's actually it's pretty much what it says. Although I have to tell you, many years ago, I had a client ask me if he could plead under first offender after his 7th conviction, and I said no. That's why it's called first offender, not 8th offender.
Okay.
But first offender is an opportunity that a defendant has who has never pled guilty to a felony in the state of Georgia or has never used the First Offender Act ever, even in a misdemeanor. And we'll get into the details, Tom and I, but essentially what a judge does, rather than finding the person guilty, they come into court, they go, I did it. And the judge accepts the plea, but instead of saying, I hereby find you guilty, they withhold adjudication. And they say, if you do A, B, and C over this period of time, at the conclusion of the sentence, you will not, well, you won't have a conviction throughout. You're not deemed to have been convicted of anything. And at the very end, if you've done everything that the court's asked you of, then your first offender will be what we call discharged. The case is over, and you can apply to have your arrest restricted or expunged, and it cannot be used against you for employment purposes. In other words, someone can't ding you because you've had that, but it will show up as an arrest. Even if you've pled under first offender, you always have to say that you've been arrested. And the carrot on a first offender is if you do what you're supposed to do, the case goes away. But if you screw up in any way, whether you have a technical violation or a subsequent, the judge can vacate, take away your first offender, and resentence you to the max you could have gotten.
Okay, that's super helpful. One word you put out there doesn't register with me because I don't think I've never heard it before, but you said you could have your arrest restricted or expunged. Expunge I know about. I think that's pretty common parlance, but what does it mean restricted? Have you to have your arrest restricted?
And from what I remember, and Tom chime in, it used to be your arrest was expunged, and then they started using it as now restricted from view. It operates the same. It goes away. In other words, if someone ran your criminal history and you completed first offender, it would not show up except in front of law enforcement folks and a few specific agencies. But Eli employer wouldn't see it if they ran the record.
Okay. All right. Interesting. All right. So now I want to follow up on what you said, and Tom, feel free to chime in too. But this is my question about if you screw up. You said the judge can vacate and then resentence you up to the max for what you pled to. So I just want to clarify something, because Powell, I mean, these people are charged in a pretty lengthy, serious RICO indictment, rife with felonies every which way. Powell only pleads to misdemeanors. Cheeseborough or Chesborough and Ellis get tagged with, I think, one felony each as part of their plea agreement. But my question to you is, once Powell does this first offender plea, if she violates, is it only the misdemeanors that she gets sentenced for?
Yeah, it's only the offense to which you entered your plea. You can't then go back and say, well, we null pros 14 counts, so we're going to jack you up on those.
Interesting.
Which means she's really only looking at up to 6 years.
Yeah.
Which is a lot, but you don't necessarily get the max. Just the judge basically gets to resentence you as if it was from the beginning.
She's looking at up to 6 years on misdemeanors?
I think that's right. 6 misdemeanor counts, so you can stack them all consecutively.
Wow. Okay. And Mark, so you could probably speak to this too, but I always liken it to what happens in the federal system, and this feels like the closest analog we have is what we would call a deferred prosecution agreement,
or a diversion,
yeah, or a deferred sentencing.
And so the interesting part here is how these actually what the procedure that takes place in Georgia under the First Offender Act. Is it that obviously here the lawyers, the Three Stooges, whatever we want to call them, have already pled guilty, so they do have a conviction in place. And so if I understand what Tom and Jeff said, those convictions they're expunged effectively.
Actually, they don't have a conviction in place.
Oh,
yeah. So what happens if I went to court for whatever, and I pled guilty, a straight up plea, the judge would say, I accept your plea, Jeff, and I hereby find you guilty of the offense of impersonating a lawyer, whatever the case may be. I now am a convicted whatever, misdemeanor or felon. In first offender, they say, Jeff, I accept your plea, but I'm going to hold off finding you guilty of anything.
Yeah. So this really does sound, Doug, to your point, this really does sound more like a diversion program, what the feds would call a diversion program, since there's no actual adjudication of guilt, if I'm understanding things correctly.
But here's what's interesting though, and because in the federal, a diversion would be, well, we were going to charge you with XYZ PDQ, and then if you mess up, I mean, look at Hunter Biden. He can face all the charges that they were gonna. He only was doing diversion, I think, on the gun thing, but now
well, he never entered the diversion. I mean, that was the whole point in that case, is the diversion agreement fell apart.
Oh,
and
well,
diversion,
that's true too.
Yeah, and a lot of times, I don't know what it's like in other jurisdictions, but diversion, which isn't really offered much here in federal court, it never makes it on the docket. Okay, I mean, you fill out a form, and depending on who the AUSA is, say, I promise I'll be good for 6 months and not do so and so, but it's not on PACER. In other words, no one can find it. And it's not in, if you ran your criminal history, you wouldn't see diversion. Whereas in state court, there's been an arrest, and you'll see that these folks were booked in and charged with whatever.
Well, we do have a variation of that in federal court. You don't see it that often, but we do see it a lot in Arizona, which is called a deferred sentencing. Whereas you'd go in, you plead guilty, it is on the record, but then you're on pretrial supervision, and if you complete it, it usually gets dismissed. And so it's that's the most similar I think I can think of, but it's really kind of interesting. So let me ask you this then. So I think I got it, but I want to move to remorse and acceptance of responsibility. This is always a big deal for us in federal court. We have to go in there and we have to express the appropriate level of remorse and acceptance so we can get our 2 or 3 levels and blah, blah, blah. So we have a situation here where, everybody's going to go in and say sorry when they just do sentencing, but this seems to be ratcheted up to a degree because part of their deal is they've got to do like written apologies to the public, to the state, to the citizens of the state of Georgia. Is that something you see very often?
Tom, you want to go first?
Only maybe when the prosecutor's got a lot of emotional investment in the case, or maybe if it's a particularly vulnerable victim, like a child. Generally speaking, though, I do not see things like that. That was kind of a surprise for me.
Here's where I've seen it before. Team Fani did this many, many years ago in the Atlanta cheating scandal. And as part of the plea offers, every teacher had to apologize. Other than those 2 instances, I've never seen it as a condition of sentence. Now, any good defense lawyer will have their clients ready to go and to provide a statement, perhaps, not like in federal court, but much more abbreviated. And if the victim's there, someone to address the court, obviously. But here it is a condition. The funky thing here, well, it's not really funky, but what's happened is it doesn't have to be in any particular form or time. So I think Miss Ellis the other day read her apology in court where the other 2 have submitted theirs. And who knows when we'll see the content of it, but I don't think that's that big of a deal. I mean, really, but it sure is odd.
Well, I think what's interesting to me is that to what extent is expressing the appropriate level of remorse a condition of this first offender diversion or whatever you're going to call it? And the reason I'm asking is because we're hearing all this chatter that Sidney Powell is really unrepentant, and so I heard this stuff. She's saying she was coerced into her plea agreement, and I went and did a little research just to see, because I don't always trust the sources, and I just went to her website, and if you go to her website, she still has the whole thing is election denialism, stop the steal. There's a donate. There's a PAC. Save America kind of pack. Like, she's full board, still like full steam ahead on stolen election stuff. And I'm just wondering, like, at what point does she put herself in harm's way with this plea agreement that she did?
Well, if we were in federal court and if she had entered a plea and they had withheld or deferred sentencing until her quote unquote cooperation was over, it's completely possible that the AUSA could, after the PSR comes out, say, I don't think she ought to get acceptance. Because let me show you the 18 things she said on social media. And judge, we're going to ask that you yank the 3 points. If they don't do that, and she's already entered her plea, and so maybe Steve Sadow or whomever does the cross of her may say, well, you pled guilty. Let me ask you this. Do you remember saying such and such on October 24th? Tell me what part of that's remorse. You could have a field day with it.
Mm-hmm.
And as Jeff points out, if this was federal court, there's still the prosecutor who has a lot of influence on what the sentence will be, and the judge, of course. Here, it's generally now going to be up to the probation officer to determine whether someone's fulfilling the conditions of their sentence. And then, of course, it goes to Judge McAfee again. And so I think, you just have to kind of treat it like a checklist. And she might be sorry, but more sorry that she got caught, or, sorry that she, didn't want to roll the dice and potentially risk a prison time sentence. But yeah, that's kind of an interesting fact of the case too, is what's good enough and who gets to decide.
Is there ever like an intermediate sanction to where, you get a little warning shot fired across the bow, like we haul Sydney in and say, we don't like X, Y, and Z. You're dangerously close to being in breach of this agreement. You better fix this or else? I
think because if they intend to use her at trial, there's definitely going to be a conversation like that. And one thing that I'm thinking about now is I did have one case where we had to write an apology letter. It represented a 17-year-old kid who broke into an apartment building to smoke marijuana with his friends. But there we had to provide the letter before we made the deal. So the prosecutor still had to sign off on it. Here, maybe I guess it has been written, hasn't been written. I'm not sure of the details there, but if I'd been the prosecutor, I might have wanted to see the letter first before I agreed to give you this sweetheart deal.
Well, and to me, that smacks of sort of it's kind of disingenuous. I mean, I feel like if you have to be forced to say you're sorry, then you're not really sorry. And in federal court, that's not going to fly.
And the other thing that I was thinking of a little bit earlier today, that is also something that happens a lot in state court, but doesn't exist, at least I've never seen it in federal court, is an Alford plea. So a lot of times you've got a client who goes, I didn't do jack, right? I didn't do anything. But I don't want to take a chance of going to trial. I think there's a reasonable likelihood I'm going to be convicted. So I'll enter a plea under Alford versus North Carolina, and the judge is going to skip over that part during the plea colloquy. Either I don't know whether any of these defendants' lawyers needed to or even broached that with the DA's office saying, how would you accept an Alford? And I think if I were Fani and her team, I'd go, you've got to be out of your mind. No,
yeah.
You either fess up or we'll see you in a couple of weeks on trial. So that doesn't happen in federal court where you can plead under Alford. But here she said, I did it. It seems pretty basic to me. Just apologize. I mean, that's a conversation you think you would have had pretty carefully with the client about. This is about as scripted as you can get on how sorry you are.
Yeah.
Doug, I have a quick question on state sentencing before we move forward. Is it typical for defendants that plead out under the First Offender Act to receive straight probation, even if it's for a felony or a number of felonies?
Is it unusual?
Is it typical?
Yeah.
Yeah, I mean, they call it first offender probation. It's the First Offender Act, but most of the time it's probation, but it doesn't have to be. I mean, you can't plead under first offender for certain offenses, but you could get a jail sentence under first offender. The rules are the same.
So let's say if you received a jail sentence 6 months, and so you complete that jail sentence, then how would you get that how would you get a jail sentence if you're never actually convicted? Okay,
so what you could, I mean, there are any number of ways. Let's just say that, I break into Tom's office because I really despise the University of Georgia football team, and I want to take away that Georgia thing behind his desk. Okay. I take it. And the judge gives me 5 years on probation to serve 6 months. And after completion of 6 months, I'm on probation for 4 years and 6 months. Okay. Under first offender. I finished my 6 months. Now I'm on first offender probation. That's how it would work.
I don't, but how would it work in terms of expungement?
Okay, so you're expunging the arrest. In other words, so the case itself, I got a sentence of 5 years to serve 6 months, but I wasn't convicted of anything. Okay, I'm given a sentence, not adjudicated of anything. And so imagine I'm just sort of I'm in legal limbo land here in Georgia, and if I do what I'm supposed to do at the end of my sentence, whether it's 6 months or 5 years, then the probation office will submit a form to the judge. It's called a petition for discharge, saying Jeff was a good boy, and the judge will sign it.
Conviction, but your conviction though will go away though.
You don't have a conviction.
You're right.
That's the thing.
Okay, so you just never have. That's right. I'm sorry. So you never have a conviction,
right?
And the reason why I'm bringing this up, it's kind of like the elephant in the room. Why would anybody plead guilty why would these 3 attorneys plead guilty in Georgia when they obviously are facing some exposure in federal court in DC? And now it kind of makes sense, because if they haven't even been convicted, then at least for sentencing purposes in DC or any other federal court for that matter, these will not count towards their criminal history.
I think it does, Tom. I think Tom and I were emailing today. My understanding has always been that first offender does count for purposes of criminal history. I mean, in Georgia, because we have it, but it's
maybe in Georgia, but not at the federal level.
Okay. No, I mean federal. I mean, like I've had plenty of cases where someone pled under first offender, and we were getting down to what's my criminal history, and client says, "Well, I don't have a conviction." And it's like, you may not, but if you got a 2 whatever sentence, you get 2 points. Your criminal history.
Well, see, that's I guess that's what's confusing for me, because yes, if they did serve a sentence, and you're right, technically, if they served a sentence, like say over 60 days, then they would get 2 points for that. But they don't have a conviction. So there would be, I mean, this would be the argument I would make in DC, that this is not part of criminal history.
Well, you're right.
If there's been an expungement, because the sentencing guidelines expressly discuss that expungements do not count.
Right. Well, you're right. I mean, if you could, let's say we got probation in Georgia, and you're right. I mean, I would
a sentence without conviction, which is something like
it's a disconnect
at the federal level.
Well, welcome to Georgia, right? I mean,
wow.
We only have an hour. But there are many more craziness stories in Georgia. But you're right. But if you had 5 first offender cases, all for probation, and you got a point for or 2 of them, you know, where you kicked into criminal history too. But you're right. It's like, how can you do that? I wasn't convicted. And
right.
Well, so Mark, I love, that's one of your great strengths is your encyclopedic knowledge of the guidelines, but we have to expand ourselves beyond the whether they'd be looking at points under the guidelines if they're charged with federal crimes, because my big question was, why would they plead guilty? Forget points. Why would they plead guilty and admit these crimes in open court when they may be unindicted co-conspirators in a much more serious federal case? Because even if they can't get the extra points at sentencing, they can use their statements against them, their admissions. They've just admitted to the crimes. So they're setting themselves up for major problems or when Jack Smith puts them into this indictment. And when we were talking about that off the record, Mark, we just thought for sure they've got some backroom deal with Jack Smith to say
what we call a global resolution. And that still may be the case. I mean, nobody's going to know whether or not there's been a global resolution with respect to Jack Smith. But here it kind of, I guess, if anything, it kind of makes sense why they would plead in Georgia if those convictions, or if they've pled but they're never convicted and certainly not serving any time, because those would not count, at least in DC. Maybe in the Northern District of Georgia, the POs there count these. I don't think they should. I think that's wrong. But certainly in DC, I don't think these would be counted as part of the criminal history. But their statements absolutely can be used against them.
Yeah. Okay.
At trial.
So
it's going to lock them in.
Let's talk global resolution. That means a good lawyer is going to say, okay, I got this thing and I have these misdemeanor pleas in Georgia, but I know I got a bigger problem in DC with Jack Smith. So I need to go to Jack Smith and say, sir, what happens if we plead here? Can we work something out globally? Right? That's what you mean by a global resolution. And it may not be on the record, may not, there's nothing on the docket, but there's hopefully more than a handshake deal that if you plead here and you cooperate here, you're all good. I'm not going to charge you. What do you guys think the odds are that something like that is happening here?
I would put it very high.
Yeah, if I were the defense attorney for any of these defendants, and there was even a remote possibility that my client would be indicted, charged in another jurisdiction, I would be in touch with that prosecutor before, or at least simultaneous with my discussions with the DA, because I know the prosecutors are going to talk to each other. I know that they've already saying, what are you going to offer? And what are you going to offer? So they're talking, and I would be ineffective if I didn't try and come up with a resolution ahead of time. Now, we didn't hear it. Well, I didn't listen to the plea, so but I'd be surprised if that came up during the plea colloquy.
It didn't.
Yeah, I didn't hear that.
But I'd be very surprised if they haven't had discussions with Mr. Smith.
And I would add to touch back on something that Jeff mentioned earlier. Yeah. The fact that there wasn't an Alford plea, because if I was the attorney, right, and I know there's this chance of this coming back up in federal court, right, I'm going to structure the plea in a way where I never said I did anything wrong, so that I can say credibly, testify in my federal case, hey, I pleaded guilty because I got first offender probation and I did not want to risk going to trial. And, the fact that they didn't do that, and they're represented by good attorneys, so I have to believe there's some kind of understanding with the feds in DC.
Yeah.
Or else you'd see, or else you'd see an Alfred plea or something like that.
Well, those apology letters.
If I could add one thing, Doug, too, I think this is probably why Rudy Giuliani has not pled guilty yet, is he hasn't been able to get a deal with Jack Smith. So there's no incentive for him to plead out, whereas these other three have received that already.
That kind
speculative, but
yeah, I mean, this. I was thinking earlier about why'd they get the deal that they got, right? I mean, they may have gotten the deal that they got because they decided we're going to try and catch the state with their pants down. We're going to file a speedy trial. That happens a lot in state court here. People will file speedies. I don't think that's the reason. I think the state was ready. They had over a year to work on this. I don't think this is a matter of them being caught with their pants down, and so we had to give it away. Good lawyering, perhaps. Yeah, I think this is the first offender deal. Okay, but because they filed the speedy, it forced plea negotiations to happen sooner rather than later, because you file the speedy, you will be tried by this date. And so it probably facilitated or expedited the plea discussions because they said, game on.
That's brilliant. Actually, I love that. That is a brilliant strategy, especially with respect to 5Ks at the federal level, because as we all know, first in, that's who gets the best deals, So this
maybe that's why they got it. I still think, Tom, and you think too, I think this is a first offender case regardless. I think if they waited literally to the last second on the eve of trial and there was some type of evidence that was going to take a long time, or some type of witness that was going to create some sort of incredible amount of resources used, that they say, here's our cutoff date. But I think this is a first offender plea all day long. So,
well, I guess what I meant is, following that brilliant insight, is I think this may have forced also background negotiation with Jack Smith.
For
a global.
Maybe.
And to go to what Jeff was saying, I mean, this really is, though, in my opinion, like a sweetheart deal. right? And that's not really getting as much attention as this is. You can't say no to this deal in these kind of cases often, even if you got a great defense. And what's important, though, is remember, this is not just some garden variety RICO case. This is the subversion of American democracy. And Sidney Powell is at the top of that food chain, right? And she just got a misdemeanor first offender probation sentence. So not only is that, kind of setting the bar, but yeah, everyone else now who below her, that's the worst that they're facing. And also, if you're Trump or Rudy, now how do you analyze the risk? If you go to trial and you lose, are you really going to get a stiff prison sentence when Sidney Powell right under you got misdemeanor probation?
Mhm.
I mean, it really is such a sweetheart deal. And in my opinion, it reflects not weakness on the part of the prosecution, but maybe something more practical. Maybe Fani Willis is willing to let these fish back in the sea to get the big one. I think that's kind of her MO in these RICO cases.
Well, it does illuminate the idea of coercive plea bargaining very starkly, I think, which is something we've talked about on this podcast a lot, which is to say, I mean, do you know, I don't want to put you on the spot, if they went to trial on the indictment as is, what kind of prison sentence they could be facing if they lost on everything?
It would completely depend on how Judge McAfee saw the case, right? I mean, it could be probation even just after a trial, or it could
no
be
mandatory minimums. And
it has to be a 5-year sentence, but that can be probated, right?
Right.
So,
See, I think that, are there trial taxes in the state of Georgia? Yes. If you come in second in trial and you testify, and we've all seen, in federal court, we've seen this too, where, they found you guilty. And so we can make the assumption that they listened to your testimony. We can further assume they didn't believe you. We can further assume that you obstructed because blah, 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 blah. And I think, AUSAs would absolutely be getting up there going, it's not probation. And we offered them so-and-so way back. And so no way are they going to get the same. So,
so they would probably,
I think there's a strong likelihood that they would not get anywhere near what they got if the case is as strong as they say, and they came in second at trial.
Yeah. So when the prosecutor comes to you and says, here's a probation deal, whether you really think you're guilty or not, whether you really are guilty or not, it's pretty damn hard to say no to that because it gives you certainty that you're going to stay out of jail. I was wondering why too, from the government, from the state's perspective, when you talk about Jeff, that they probably weren't caught with their pants down. They probably were ready to go to trial, and that wasn't the deal. And I agree with that. But when Sidney Powell and them requested speedy trial, my first reaction was, well, that's pretty brilliant, because if they're working with Trump, he gets to feed these little fish to the wolves and then gets a full not even a preview, like this, gets to see the whole movie of what the witnesses are, what the evidence is, what the strategy at trial is. And he gets, I mean, wouldn't every defendant love to be able to watch their trial before they participate in their trial?
I mean, but I also think that one of the reasons that the state made a first offender probation terminate early, which we can talk about in a sec, is because they didn't want what you just said to happen. They don't want his formerness and Mr. Giuliani and everything to have the benefit of sitting down in front of their TVs with popcorn and watching the strategy for 3 months.
Yeah,
They'd rather
not worth it.
His trial.
Yeah. It's not worth it to them. And then there's always the domino effect where they hope that they can get the little folks and that the big folks get the pressure put on them.
And it's highly probable that there was a global resolution. I think it's almost certain now, given this exposure, because I don't see why anybody would enter a plea in Georgia, why any of these attorneys would, knowing this exposure. I mean, not only are all these statements going to be used against them in DC if they were decided to go to trial, but for sentencing purposes, they're kind of already screwed. I mean, they're not going to receive the 0-point offender, and they possibly could end up in criminal history category 2 if they do not satisfy the terms of their probation. One last thing I will add that I noted in some emails before we got online here is that if they're sentenced in federal court prior to their probation being finished in the state court, that could affect their sentence too. So I'll just put it that way. There may be some issues with that as well. It's very complicated.
All right, so
You
we've
need a
made
flow
it.
chart. I mean, you
We've
really
made
do
a
need
prediction. Well, we've all predicted, and I agree. I think there's got to be a global resolution too. So, well, that's going to be remain to be seen. But what I'm most curious about is the Kraken lady, because it
Yeah.
feels like she's cruising for a bruising. If she's got so much writing on this in federal court, you would think she would be a little more circumspect in what she's doing and what's on her website. So that single fact makes me suspicious that she doesn't, because if I was really worried about federal charges and keeping a good global resolution intact and getting out of this unscathed, I don't think I'd be doing some of this stuff. I have one last question. It's a little far afield, but in doing my research, I saw there was a lot of chatter about one of Jenna Ellis. So Ms. Ellis had a little problem, which was her legal fees were not going to be covered by Donald Trump. He just cut her loose and threw her under the bus. So she did a little online fundraising campaign, and it looks like she raised over $200,000, $217,000 to be exact, to cover her legal fees. And now people are calling for her to return that money because they're saying she didn't go to trial, she didn't prepare for trial. It was a misdemeanor, first offender plea. No lawyer in his right mind would charge over $200,000 for that amount of work, and she needs to return the money. And she's saying, no, that didn't even begin to cover my legal fees. Do we believe? Does that ring true? I mean, I don't know how they do things down in Atlanta, but it seems like somebody got paid a lot of money. I don't know.
So attorneys in Georgia are allowed to charge a reasonable fee. Okay, and that can be a flat fee up front. You can ask for more for a trial fee, and you can factor in things like opportunity cost. Yeah, I did a first offender probation for Miss Ellis, but I conflicted myself out of representing Donald Trump. Put a price tag on that.
Yeah, I mean, if I was quoting a fee about, okay, this has to go all the way to trial, I guess 200,000 is a pretty good deal.
The other thing, and again, I can't speak to other jurisdictions. I can absolutely speak to the Northern District of Georgia and to a good number of the 159 counties in Georgia, but not close to all of them. If you file an entry of appearance here in Georgia, you're in. And
you're in
so
it for the long haul.
The lawyers are, especially you're filing a speedy trial, right? So there's no, oops, I really didn't mean to file the speedy. If you then didn't get paid, that's no one's problema, but yours. And who knows what the original offer was? I mean, I remember when I first started as an assistant DA, I was in DeKalb County, and this defense attorney, who's a great guy, asked to approach. If I may, he'd say, if I may. And he approached the bench and said he was going to need a short continuance. And the judge says, why? He says, I'm having some witness issues. He says, well, who can't you find? He says, I'm having trouble. We were whispering at the bench. I'm having a hard time finding Mr. Green. And I'm so new. I look in my file and I go, there is no Mr. Green. The state's ready. And then I found out that he hadn't been paid yet. And so the judge gave him a little more time to find his witness. But, you've got to, with a case like this, you have to be thinking, I could be sitting here, right? How many months in a row? And if I don't get paid up front, it's nobody's fault but mine.
Okay. Well, that makes sense. And I must say, if I'm quoting a fee to be stuck in this case, possibly throughout trial, 200 grand is a steal from where I'm sitting for a high profile case like this. All right. So everybody needs to back off Jenna Ellis. We're going to come to her defense on that. That sounds legit to me. Last question. And this is prediction. So I've got this indictment in front of me. We've had 4 people pleading guilty, but and I don't recognize a lot of names on this indictment, but I'm just going to go through a few names that we might recognize, and just let me know if you have any predictions about what's in store for them in this case in Georgia. We have Donald John Trump as number 1, Rudolph William Louis Giuliani as the number 2. Charles Eastman and Mark Meadows And then after Kenneth Cheeseborough is Jeffrey Clark. So we've got Trump, Giuliani, Eastman, Meadows, Clark. What do you think? Are we going to see a trial in this? Are we going to see pleas in this? What happens?
Great question. I'll try to answer it first. My gut says Trump takes it to trial. I think Giuliani pleads. I think Eastman might go to trial. I mean, he's the law professor. I mean, he might feel a certain principled kind of way about this. The others are probably pleas, I think, but maybe some Alfred pleas. I mean, to some clients that really matters, right? The ability to say, I'm not guilty, but I'm pleading. And I don't know. It depends how important they could be to the prosecution if they allow that.
But I think the prosecution, I mean, when you asked why earlier, Jeff, one of the reasons that the prosecution may have is I need you to come into court and say you were wrong and that these people were wrong, or that you told them they were wrong, or this, that, and the other. And if they do an Alfred plea, they don't have to say anything. They're of no use to the prosecution in trial if they do an Alfred plea, because they're saying I didn't do it, but I pled because
they're worthless to the state. And I think, if I remember right, is that each of these defendants, as a condition of sentence, is that they agreed to, quote, cooperate with the investigation. Yeah. I mean, cooperation does not mean make up something at trial. You can cooperate about information that you have. And so, I mean, we've had defendants, in federal court where the AUSAs go, Jeff, your guy doesn't know anything. I can't use him. So it may be that some of these defendants, they need for a very specific reason, and they know they don't know anything about the other defendants. And so, it depends on how bad they want them and how bad they need them. I think the offers will be extended for a long time, and whether the remaining defendants say game on, I double dare you, stay tuned.
Well, and I think Giuliani's going to be a real one to watch because of what Jenna Ellis said in her allocution, which was, I relied on more senior attorneys, people I trusted, people I looked up to. Had I known they were lying about this, I never would have done anything like it. So that's going to be, I guess, really interesting. And I think you're right, Mark, that we're not going to hear a peep out of him until he figures out his little problem he has with Jack Smith. All right, gentlemen. Well, I want to.
I'm sorry. I just have one last question, and forgive me if we already discussed this. My brain isn't functioning. But why did the Kraken get misdemeanors, and everybody else has so far has had to plead to a felony? Is it because she was just first in line, or one of the first in line, or is it maybe because she has more or better information to add?
Or more serious mental health issues as mitigation, but sorry.
Well,
yes, gentlemen.
Well, I would wonder what the ramifications are for her license. And I haven't done a deep dive into that, candidly speaking, but maybe there's a difference between misdemeanor interference and what Jenna Ellis pleaded to, which is a felony, right? Or Chesborough. So that's what they're
all lawyers. I mean, so they're all lawyers too. So they have the same jeopardy in terms of the license. So I'm not, any idea though why, other than the license issue, why she would get the misdemeanor offer? Is it just because first in line?
No, I don't necessarily think that just because someone was first, that means that the state's going to give away a charge that they truly believe in and that they need for purposes of the rest of their investigation. Sometimes, prosecuted along. Sometimes over time, prosecutor goes, you know what, I can live with a misdemeanor. I'm okay with this defendant getting this. And if anybody ever asks, I can make a distinction for the following reasons. So sometimes it happens.
Okay. So there is a possibility that we could see more misdemeanor resolutions in the future.
I mean, it's got to be blessed by Team Fani. I mean, the judge can't turn to the state and go, well, why can't we consider a misdemeanor? It has to be blessed by them. So you can ask, but you don't get it unless the state says okay.
Yeah.
And I would wonder if part of this is about trial strategy, having a factual basis for concrete specific acts, because they charge with a lot more than these acts, right? And maybe she wants to deny some of it. And has a certain narrative, and maybe they're okay with this part of the narrative and not that part of the narrative. Maybe
Right.
those 6 misdemeanor acts are more important for their creating the record they need for trial.
Right.
Got it. Okay.
I think that's right too, because I see that in federal court as well. When we have cases with co-defendants and someone's pleading, the government gets really active in crafting that factual, like really, really interested in the language, because they're looking to the future. They're looking forward to being in court with these other defendants who don't plea.
Right.
Yeah. All right. Well, this was enlightening, as I knew it would be. So I want to say thank you, Jeff Brickman and Tom Church. I hope that nobody listening to this podcast ever needs a criminal defense lawyer in Georgia. But if you do, here's 2 that would fit the bill very, very well, especially if you had a federal case and a state case, happening at the same time. Heaven forbid. But let's talk again. This was fun. I'm sure, there'll be more pleas. So I'm probably going to have you guys back if that's okay. But thank you so much.
Well, this is fun. I appreciate it. It's great seeing y'all, and have a good weekend.
And thank you, Mark Allenbaugh, as always. And I'll talk with you soon.
Okay.
Thanks, everybody.
That's it for today. But before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign up on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.